This message is brought to you by the Pepperidge Farm Owners Association of America. Protect your equity, protect your contract, protect your future. This video will go over the impact of the proposed Employee Misclassification Class Action Settlement for Illinois, Massachusetts, and California. But before we begin, the topics of slides and discussions are about a legal matter. None of the information provided is an official legal opinion or any kind of offer to provide legal advice. If you require legal advice, please hire an attorney and show them this informational presentation. This presentation and discussions are for informational purposes only. So let's get started. Soon, distributors in Illinois, Massachusetts, and California will receive a packet from the court on the proposed settlement. It is extremely important that you review this information with your attorney so you understand the ramifications of the settlement if approved. This settlement stems from the employee misclassification lawsuits that were filed in these 3 states, but the impact will be felt by the entire distributor network moving forward. Here are the average payout to accept the monetary settlement and, more importantly, a new contract. POAA does not object to Pepperidge Farm paying distributors in settling the employee misclassification lawsuit. POAA objects to Pepperidge Farm dangling that money to hook distributors to accept a new, radically different contract. One that will empower Pepperidge Farm not only to continue the unfair policies and practices alleged in the class action complaints, but also authorizes Pepperidge Farm to expand unfair policies and practices that were not raised in the complaints. POAA believes the entire settlement isn't fair, reasonable, or adequate. There is no valid reason for a change in the contract when the entire scope of the lawsuit dealt with employee misclassification. The new proposed contract is much weaker and more vague than the current contracts that distributors enjoy. When looked at analytically and with experience as our guide, many perceived positive points of the settlement become negative when viewed closely. Remember how Pepperidge Farm reinterpreted or any portion in paragraph 20 of the Blue 2001 contract, despite the fact that the title page, Schedule A, and paragraph 1 of the contract describes the geographic territory, not specific accounts. This presentation will examine 9 examples using the Blue 2001 Redline Consignment Agreement. Our first example deals with no more plus outs found in paragraph 2. But is that really the case? Let's take a closer look. Under quantities consigned, you notice the word accept has been changed to order. This gives the appearance that Pepperidge Farm will no longer force product on distributors that they didn't order. But that right currently exists under current contracts. Paragraph 2. Bakery reserves the right to allocate its products as nearly proportionately as practicable if the overall demand for its products exceeds its production. They do not have the right to plus out orders for any other reason. Bakery shall have the right to distribute such additional products for so long as the consignee opts out of doing so, and the consignee shall not receive any payment in connection with the additional product distributed by Bakery. Meaning that Pepperidge Farm can use other measures to get product to the market without compensation to the distributor. We also find that Bakery must give 7-day notice unless Bakery shall not be required if doing so is demonstrably commercially unreasonable. Analysis. If you refuse plus outs, Pepperidge Farm can direct ship to stores and not pay you anything. What happens when the product goes stale or is damaged during shipping? Our second example examines stale and bulletin price definition. The true purpose of automatically binding class members to the new contract is not to better protect owners from Pepperidge Farm because the parties failed to clarify the definitions of stale product and bulletin prices to stop 2 of Pepperidge Farm's most outrageous and well-known predatory practices. The original intent of the references to Pepperidge Farm's stale policy was to grant Pepperidge Farm discretion to establish the shelf life for its consigned inventory. For decades, Pepperidge Farm also required owners to sign a wide variety of different stale policy amendments to their contract. But the new contract fails to offer any stale policy amendment. which is a serious problem because another new provision authorizes Pepperidge Farm to deduct any amount from our commissions under the undefined stale policy, which we will discuss in more detail in just a few minutes. First, everyone should already know that POAA has been sounding the alarm for quite some time about Pepperidge Farm reinterpretation of bulletin prices. Please check out our Protect Your Equity video series that explains in detail how Pepperidge Farm has been subsidizing its trade promotion by skimming distributors' commissions. The third example examines elimination of weekend deliveries in paragraph 4C, which removes provide distribution services to all retail stores on such days of the week, including weekends. However, notice what is inserted. Bakery may from time to time publish and or make available to consignee onboarding assistance, sales and promotional information, recommended service frequency and day of the week standards, recommended sales goal, business planning guides and assistance, business consulting via route rides or route consults. While the appearance is less oversight, the reality is Pepperidge Farm will have more control in recommended service frequency, day of week standards, route rides, which isn't defined and is now part of the contract. However, consignees shall have sole discretion without suffering any adverse consequence to use or not use any of the foregoing offering as it sees fit. Preliminary analysis. Pepperidge Farm still maintains control with their recommendations. Adverse consequences is not defined, and how exactly does the distributor contest the consequence? The fourth example examines planogram noncompliance found in paragraph 4. This section allegedly gives distributors the ability to deviate from Pepperidge Farm planogram at chain accounts. It states, consignees shall have the right to obtain third-party customer written approval pursuant to a form provided by bakery to deviate from such third-party customers' required or suggested planograms for placement of products in that third-party customer's location. Preliminary analysis. Pepperidge Farm is going to provide the distributor with a form to disregard the Pepperidge Farm planogram. What does that form look like? If such approval is given at the local level of the third-party customer and not rejected at the corporate level, the consignee shall have the right to distribute products as agreed upon between consignee and the third-party customer. If such approval is rejected at the corporate level of the third-party customer, the consignee shall comply with the third-party customer's planogram. Preliminary analysis. So Pepperidge Farm will provide a form to modify the planogram that requires a store manager's signature. Then Pepperidge Farm will take that form to headquarters for approval. How many managers will sign a form knowing that Pepperidge Farm will take it to their superior for approval? The fifth and extremely important example examines authorized deductions found in paragraph 24. Consignee hereby authorizes bakery to deduct from any amounts owed under this agreement, any amounts owed by consignee pursuant to the stale policy existing from time to time, any pallet or other fees that may be owed by consignee under this agreement, including the amendments hereto, any maintenance or other charges related to the purchase and use of handheld computers or other devices used by consignee, and any other deductions the party may agree to from time to time. Preliminary analysis. Distributor is agreeing to a thrift policy on items that they never legally owned. There's nothing stated on items direct shipped into accounts. Pallet fee costs are not stated. Maintenance fees are now mandatory and not stated. Let's examine what Snyder distributors pay. They currently lease their computer for $40 a week or $2,000 annually. They have a commission between 5 and 7% when selling or splitting their business, meaning a $200,000 route sale would have at minimum a $10,000 fee. Is this in our future? The sixth example, recalls, found in paragraph 25. Recalls. Consignee shall assist in all product recalls as requested by bakery and otherwise meet any and all of consignee responsibilities related thereto under applicable law. In the event consignee is requested by bakery to assist in a product recall and consignee removes recall product from retail stores in a prompt manner, which shall in no case be longer than within 24 hours of notice of the recall, consignee shall receive a 2% commission on all recall products so removed. Did you notice the stipulation? Distributors have 24 hours to remove recalled products from all accounts. Many distributors cannot physically accomplish this in a 24-hour time frame. How much business would be lost if your only concentration was writing credits because you had 24 hours to do so to receive a 2% commission? Example 7. Damaged product found in paragraph 27. In the event consignee is charged for consigned product damaged in store after delivery by consignee may seek forgiveness from such charges from bakery pursuant to bakery stale policy existing from time to time. If in bakery's sole discretion not to be unreasonably applied, consignee demonstrates that consigned product was damaged in store after delivery and through no fault of consignee, bakery will provide stale forgiveness for such product pursuant to bakery stale policy existing from time to time. Preliminary analysis. The distributor is responsible for any damaged product in any account for whatever reason. Pepperidge Farm, in its sole discretion, may forgive that damaged product per the stale policy. The phrase time to time is vague. Why not be more specific or not even have this phrase in the contract? The 8th example found in paragraph 28 is extremely disturbing. Exclusive alternative dispute resolution process class and collection action waiver. Consignee and bakery agree that the dispute resolution process set forth below shall be the sole and exclusive method by which any and all covered disputes, as hereinafter defined, shall be resolved and decided between consignee and bakery. Item 5 is very troubling. The arbitrators shall maintain the confidentiality of the hearings unless the applicable law provides to the contrary. The arbitrator shall have the authority to exclude witnesses other than the party and the party's representative from the hearing during the testimony of any other witness. The arbitrator also shall have the authority to decide whether any person who is not a witness may attend the hearing. So, no witnesses and the decision is confidential. It sounds like the Star Chambers from 400 years ago. Who would ever give up their right to a trial by jury? 6 pages of process, or 1/3 of the contract, is devoted to forced arbitration. Here are 5 concerning quotes from June 5th, 2019 LA Times article. Chase says arbitration provides better outcomes for consumers. Nope, says researchers.
A recent academic study confirms what consumer advocates have been saying for years. Mandatory arbitration is a rigged system. Rigged, that is, in favor of businesses. The whole game is stacked against us, said Amit Saru, a financial professor at Stanford University's Graduate School of Business and a co-author of the study. Remember, Pepperidge Farm is paying for the arbiter when reading this next quote. They found that companies routinely pick arbitrators with track records of making industry-friendly decisions. They also found that arbitrators know that the more they rule in favor of businesses, the greater the likelihood they'll be tapped for future cases and future paychecks. This is not like having judges who get paid the same no matter what happens, Saru told me. With arbitration, you only get paid if you're selected as an arbitrator. They have incentives to slant towards the business side because they know that those who don't do so won't get picked. Not only do these provisions prevent you from filing a lawsuit in the event of a grievance, they block you from joining others in class action suits, thus denying you access to the single most powerful recourse open to consumers and employees.
And our last example, paragraph 29, Class Collective Action Multi-Party Waiver. The title of this paragraph says it all. Distributors will not have the ability to join with other distributors in a lawsuit or class action lawsuit against Pepperidge Farm. Distributors must use the process described in paragraph 28. Again, this settlement only pertains to those in California, Illinois, and Massachusetts. Should owners in other states band together to form a class seeking to overturn the loss of club stores and future club stores' rights, payments per bulletin price, not off invoice, or any other of our many issues, those who accept this settlement will be excluded not only from participating in class lawsuits, but also from receiving any award or being part of any judgment. Rest assured, if this settlement is approved, this will become the new contract whenever someone splits or sells their territory. The amount of rights lost in your contract dwarfed a few positive aspects of the settlement. Ask yourself, why do I need to agree to a new diluted contract that mainly benefits Pepperidge Farm on a lawsuit that dealt with employee misclassification? Employee misclassification or admission of any wrongdoing by Pepperidge Farm is not mentioned anywhere in the proposed settlement. Pepperidge Farm will benefit greatly by having the approximate 900 distributors agree to a court-mandated new contract, and that will affect all distributors in the long term. As mentioned earlier, POAA does not object to Pepperidge Farm paying distributors and settling the employee misclassification lawsuits. POAA objects to Pepperidge Farm dangling that money to hook distributors to accept a new, radically different contract. This is important. By default, those listed in the 3 states are already opted into the settlement, even if you do nothing. There are specific steps that must be taken to reject this settlement. That is why POAA hired Fox Rothschild and will pick up the legal fees in regards to this issue. It is that important. For more information, email legal@teampoaa.org.